have a puzzle that we started in there.
Okay.
We've been doing art, trying to take the stuff off the wall to make new art put up there, like having a good time with one another. But we're drinking. We had a bottle of wine last night.
Okay. Fine.
So then it's like we decided to play hide and seek, right?
Okay.
So he gets in the suitcase. Okay.
Who is this guy?
That's my ex-husband.
She's been charged with second-degree murder, and now after burning through 8 attorneys, 7 of which were court-appointed, she's now going to have to represent herself. Now, every criminal defendant has a right to counsel under the Constitution's 6th Amendment. So how does this constitutional right square with the judge's decision here? Let's get into it. So if you don't know who this is Sarah Boone. She's been charged with murdering her boyfriend Jorge Torres back in February 2020. It's the so-called Suitcase Murder trial. And it's called that because she's alleged to have killed him by zipping him up into a suitcase, preventing him from breathing. And realistically, if you've seen anything about this case, you know the evidence against her is actually pretty stacked. For one thing, she apparently admitted to zipping him up into this suitcase, saying that it was essentially a drunken game of hide and seek gone wrong.
Last night. Okay. So then it's like we decided to play hide and seek, right?
Okay.
So he gets in the suitcase. Okay.
Who is this guy?
That's my ex-husband, my former husband.
How did he live here with you guys?
No, I called him over here.
Okay. Okay.
I didn't know what to do.
Okay.
I didn't know what to do.
Okay.
So then he came over here.
Here, let's talk in private, okay?
I called you guys. I tried getting your CPR. The problem is I fell asleep. I fell asleep.
When did you do CPR?
This morning when I found it.
Before you called?
Yes.
1 o'clock right now.
I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs and I was like, oh, he's in the suitcase still.
And there's even video that she herself took during the whole ordeal. In the video, when he's zipped up in the suitcase and pleading multiple times for her to let him out, saying that he can't breathe, she responds to him by saying things like, well, that's what I feel like when you cheat on me.
Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Real or ransom. Might want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you cheat on me.
Sarah.
So all in all, there's some pretty strong evidence here of her committing the act and showing an intent to at the very least harm him. So the likelihood of her getting acquitted in this case, just based on the information that's publicly available, is fairly slim. But as outrageous as that whole story sounds, the most frustrating part of this overall story is arguably the number of lawyers that she's burned through since that time. In total, as I said before, she's had 8 attorneys, 7 of which were court appointed. And each time, one by one, the attorney had to withdraw for one reason or another. In the meantime, Sarah Boone has also developed a habit of writing letters to the court complaining about her lawyers for all kinds of reasons. And I will say that the strength of the underlying case against her might have something to do with at least part of the underlying reason for this long parade of attorneys here. I say part of the reason because it seems that not every single attorney withdrawal here has really been her fault. For example, according to the judge's recent order on this whole issue, at the very beginning of her case, on February 26, 2020, the local public defender was appointed to represent her. Around a couple weeks after, on March 9th, 2020, that public defender moved to withdraw for the simple fact that Boone had hired her own lawyer. Now, a quick note, when an attorney is on record as representing a client in active litigation, whether that is civil or criminal, they need to get permission from the court to withdraw from the representation. Even if the client has fired the attorney and said in no uncertain terms, hey, I hate your guts, stay far away from my case, and in fact, stay as far away from me as possible, the attorney still has to get permission from the court to withdraw. The reason for this is because litigation is a massively complex process, and even if you know what you're doing, because you're a trained lawyer and you've been practicing for a while, for example, mistakes can still happen. And so, of course, that possibility is magnified when we're talking about somebody who is left to represent themselves, perhaps even when they're in between lawyers. So courts always want to make sure that a client isn't left out to dry simply because their attorney ghosts them at a really vulnerable time. And because of that, the attorney of record in the active litigation needs to get permission from the court to withdraw. Anyway, so as I was saying, the withdrawal of Boone's first attorney of record is arguably not a sign of her trying to delay the trial or to be unreasonably difficult with her legal counsel. And the same is true of her third attorney, who was also from the public defender's office, as well as her fourth attorney from the Office of Criminal Conflict and Civil Regional Counsel, and her fifth attorney, Mark Counsel, all three of whom apparently had a conflict of interest. However, the majority of these 8 attorneys later withdrew due to irreconcilable differences. For example, there's Mauricio Padilla, the second attorney in this case, who moved to withdraw on April 18th, 2022. He clarified that his irreconcilable difference came from the fact that the attorney-client relationship had become adversarial. Then there's Frank Bankowitz, Boone's sixth attorney, who moved to withdraw on December 19th, 2022, and again on August 22nd, 2023. There's also Winston Hobson, Boone's seventh attorney, who moved to withdraw on February 1st, 2024 under these grounds. And finally, there's Patricia A. Cashman, Boone's eighth attorney, who moved to withdraw on June 11th, 2024, also, once again, citing irreconcilable differences. Now, some of these irreconcilable differences appeared from the record to be issues where the attorneys were saying that Boone was essentially just trying to take up literally all of their time, and that was interfering with their ability to provide counsel to their other clients. And I will say this is a legitimate issue, since attorneys also have an ethical duty to each of those clients, and it's unreasonable for anyone to expect these attorneys to waive off representing other clients just for the one. But 3 of these lawyers, Padilla, Hobson, and Cashman, all highlighted that they also had a specific ethical reason for why they couldn't continue the representation. To be clear, we don't know specifically what those ethical considerations were, but this could mean a number of things. There are a handful of reasons why an attorney could say, for ethical reasons, I have to bow out of representing this client. Like I just mentioned, it could be that she's trying to soak up all of the attorney's time, and that's preventing them from representing other clients. That's a potentially ethical issue. Another possibility is that she was insisting on taking a particular course of action in her case that the attorney strongly disagrees with. It could be a course of action that, for example, requires dishonesty, or it could be something that for other reasons the attorney would just never recommend. But considering how strong the case is against Sarah Boone from the outset of this case, again, based on information that's just publicly available, I wouldn't be surprised if there was a piece of this that was coming from her desperation over fighting basically an unwinnable case, possibly even by whatever means necessary. And on top of that, there's a potential here that another factor is a refusal to accept the reality of her situation when that reality was presented by these various members of this parade of attorneys. Of course, take that all with a grain of salt. I want to flag for you here that this is a bit of a suspicion on my part, and not to be taken as a factual allegation, as if I have some kind of behind-the-scenes information. I don't. But Sarah's communications to the court, both through her public letters that were filed on the record and also her verbal in-hearing statements, again, publicly stated, might just hint at that. As an example, here's Sarah Boone complaining to the court about Patricia Cashman in one of the latest hearings. She specifically talked about how she thought Cashman should be, quote-unquote, nicer to Boone.
I am doing my best to let everyone know who I really am, as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always, the reason why I'm here is hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying and see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win and more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.
Now, let me get one thing straight. Attorneys have tons of ethical obligations to their clients, but being nice is not one of them. And in fact, sometimes it's the role of the attorney to give their client the hard, cold truth about their situation, even if it means having to be the a-hole in the room. So if you've been an attorney in litigation long enough, guaranteed you have had to be that person at some point, because it's way more important for your client to have the real information about the outlook of the case than for them to think that you are just a nice person who's there to help them do whatever it is that they want you to do. And I will also say that I don't know Patricia Cashman, the lawyer that Boone was just complaining about in this particular clip. So I don't know if she's particularly abrasive or if she's generally a warm, empathetic person. But based on what I do know about her background, I do understand that she's been practicing criminal law for a very long time. And what's more, she started her legal career at a time when it was much harder to be a female professional in the legal industry, which was much more male-dominated than it is even now. So all of that gives me the sense that most likely this is one tough lady who has been through the fire and who knows her stuff. That, coupled with Boone's complaints about her needing to be quote-unquote nicer to Boone, and of course along with Boone's trend of complaints about basically every attorney that she's had before Cashman, that all tells me that most likely what happened here was Cashman was just telling Boone the reality of the situation, and Boone did not want to hear it. And make no mistake, Boone has sent letter after letter after letter to the court complaining about most, if not all, of these attorneys one by one. She's made a number of different kinds of complaints in these letters, but it seems like the biggest recurring theme is that she says, they're not returning my calls, they're not talking to me as much as I want them to talk to me. Now, I will say this can in fact be a legitimate complaint. Attorneys do in fact have an ethical duty to keep their clients reasonably informed about the litigation. But there always has seemed to be a disparity between Boone and whatever lawyer was representing her at the time about what it means for the client to be reasonably informed. As the story has developed, it definitely seems that her interpretation has turned out to be, talk to me every time I want to talk to you and spend all your time on my case, regardless of whatever else you have going on. And that simply is not the definition of keeping a client reasonably informed. But okay, all of that aside, what about Sarah Boone's Sixth Amendment right to counsel? After all, this is a criminal case and she's entitled to that right? So if that's the case, how do we get here? Well, this is where it becomes worth the wait for this whole long ordeal. You see, people who have been following the story for months and even years now have undoubtedly felt growing frustration with this court for just allowing her to be appointed attorney after attorney and in the process seemingly forever delaying her trial. And even from the beginning, with the very first attorney switcheroo, the state did apparently note their concerns that Boone could be using this as a delay tactic to forever keep her trial from happening. But at the same time, in her various communications, Sarah has pinky promised that what she really wants is for this case to finally move forward. She just wants the right attorney for the job. That's what she says anyway. But you see, through this whole process, the court hasn't just been giving her a new attorney and letting her get away with it, although it certainly may have felt that way to many at times. Rather, the court was keeping a very detailed record of this whole long saga, and this latest order allowing the withdrawal of Boone's eighth attorney is where it all comes together. You see, not only does it detail the reasons for all of the other attorneys' withdrawals and the hearings that they had to go through to ensure that her rights were protected along the way, the court's order also details the number of warnings that the court gave to Boone along the way, saying, hey girl, hey, and the longer that this trend continues, the more you run the risk of forfeiting your right to counsel, and you can totally end up having to represent yourself if you're not careful, and there are risks involved in doing that. For example, the court gave her first warning on this on May 10th, 2022. Then on December 27th, 2022, she was given another warning where the court told her she's not entitled to an endless line of court-appointed attorneys and that she might end up representing herself. Then very recently, on February 9th, 2024, the court again warned her about the possibility that Boone could end up representing herself if she couldn't work it out with one of these attorneys, and that this could be dangerous to Boone's overall case. So in the moment, as all of this was going on, this was of course frustrating to watch. But make no mistake, all of this was purposeful by the court. They wanted to make sure that Boone got absolutely every possible opportunity to move forward with competent counsel. And they wanted to make sure that there was a detailed record of Boone getting warned about the consequences of her actions and the risk of having to represent herself at some point. And that's because the court was following case law for what was required for Boone to get the determination to have forfeited her right to counsel. So what does it mean for a person to forfeit their right to counsel? That is a determination that courts can make when there's enough of a showing that a defendant has abused or manipulated the right to counsel through their actions. This can totally be done by waiver of conduct, where the defendant has actually acted in a certain way that they are waiving that right. And in that kind of a case, the defendant has to have been warned about the consequences of her conduct, including the risks of proceeding pro se. In other words, representing herself. The result of this determination is a court can say, sorry, you're not getting appointed another attorney. And if you can't afford to hire one now, you got to represent yourself. In other words,
see, as you can see, the more you around, the more you're going to find out.
And as the court said in its recent order finding that Boone forfeited this right, Boone showed a, quote, recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, of Bankowitz, and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. And ultimately, the court said that it has become apparent to the court that the defendant will not permit herself to be represented by anyone. And ultimately, the facts here, according to the court, amount to a binding forfeiture of the right to counsel. And what's more, the court did also address the fact that Boone has been verbally at least telling the court that all she wants is for the case to move forward, of course, just with the right attorney. Specifically, the judge wrote, actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over. Allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of this case on its merits, the concept of which was first brought to the defendant's attention on May 10th, 2022. So, there you have it. After 4 years, 3 months, and 5 days of this case going on, Sarah Boone is finally being told by the court that she is going to have to represent herself. This is definitely an extraordinary measure taken by the court. They do not ever take this kind of a decision lightly, particularly in a criminal case where, again, the default is that the defendant has a right to appointed counsel if they cannot afford one. But in my opinion, the facts in this particular case show that this decision is the right one because she 100% has been abusing the process here, seemingly to try to delay this case forever. But now she is representing herself, and the trial is still scheduled to move forward on October 7th, 2024, with no sign of further delay. But those are all my thoughts. What do you think? Do you think that maybe she should have been given more chances? If you've been following this, do you think that this case was just going to be a permanent carousel of attorneys with no end in sight? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics like this one, be sure to hit the subscribe button and the notification bell so you can find out when the next one is uploaded. And if you're really loving the content and you want to know how best to support the channel, and perhaps in the process get perks like early access to videos like this one, consider becoming a member of Byte Club. You can join either through YouTube memberships or by supporting on Patreon. Links to both are in the description below. Otherwise, see you in the next video.